Hello, everyone. Hi, this is Immigration Times with Michelle Fanger. I'm excited that you're joining us today. And today I have some wonderful questions that I'm excited to respond to so I could provide the information to everyone. As you know, I'm an immigration attorney, and on this program, I love to provide the information for individuals here, give them the tools that they need so that they can remain legal and not have any major issues. Okay. So, one of the major questions, which I think is very important because people consistently have issues, and it's regards to citizenship. So the question is, I have a misdemeanor on my record for years ago. Should I disclose that information on my naturalization, even though it's not qualifying? Okay, so whatever charges you have, if you were detained, cited on the immigration document for naturalization, they ask that you disclose it. So you have to disclose all that information. Although it doesn't impact you immigration-wise, where they'll put you in deportation or a denial, but it's important that you disclose all the information. Disclosing the information meaning also you go to the court and try to get records of that, the disposition of your case, to show the outcome of the case or to see what happened. Or, the police report, if it was just a citation, nothing happened. But you have to disclose all this information because they're asking for that information. It doesn't matter how long ago, you still have to disclose it. If you do not provide that information, and they look at the document that you completed, the form, and it's not there, they're going to say, immigration is going to say that you're willfully not providing this information. They don't know that you're thinking, all right, it's not that important. They're just thinking, we ask you for the information, you need to provide the information, so you're misrepresenting to us. So you know what, you're going to have an issue. They might deny you, sometimes they deny you, sometimes it can end up into a deportation scenario, worst case scenario. But more than likely, they'll just deny you getting the citizenship and tell you to reapply. But it's very important that whatever it is that you do, list it on the application form and always be honest with it. Don't ever say they will never know. You don't know, because they do their own background information. I remember I had a client where he had an issue in his home country and he thought immigration would he never disclosed it to me. It didn't show up when we did the fingerprint. We did an FBI background check. It didn't show up. But when he went in, it showed that he had this offense from his home country. And then that created a problem. So just be mindful to always be honest and upfront in regards to immigration. All right, disclose. Don't think. All right. I hope I was helpful with that question. And then I'm moving on to the next question. And it's regards to the question was, I'm a green card holder, married to a U.S. citizen. Your spouse becomes abusive. How can you stay in the U.S. without jeopardizing your immigration status? This question, I have to break it down. So if you're a green card holder where you didn't get it through your spouse, you're not going to have any issues in regards to being deported or anything. If your spouse is abusive. If you have a conditional green card, though, where you have the 2-year requirement to show that your marriage is legitimate, like after 2 years, you have to resubmit documents to show that yes, it's a legitimate marriage, and then USCIS immigration will remove the condition and give you your 10-year. If during that 2 years your spouse is abusive, and this is based on what I'm reading from the question, if your spouse is abusive, you don't have to stay in that marriage because you're being abused and you want to get an immigration benefit. USCIS immigration understands that this happens a lot. So if you're going through an immigration matter, the conditional, and you are being abused, you could, if it gets to the 2-year mark where you're supposed to remove conditions and you're fearful that, what will happen to you, you don't have to stay in the abuse situation. You could file for yourself It's called a self-petition to remove the conditions of the green card. But at that point, you will state why. And the why is that I'm petitioning for myself because my spouse is abusive. You can't only say that, you have to provide evidence of it. All right. And just a disclaimer that I should have done in the beginning, although I'm providing this immigration information, I'm not your legal representative. I have to say that. So yes, so yeah, you could still go ahead. Nobody should stay, even if you haven't gotten your green card yet and your spouse hasn't filed your petition, but they're being abusive to you, you could do what's called a VAWA. And this is for victims of abuse. Because they do understand immigration. Everybody understand that marriage doesn't last forever. And people do go through abuse scenarios. So this is why they have certain relief for individuals who are going through abuse, because they're saying you don't have to stay in that position because you want an immigration benefit. And nobody should take advantage of you because you are seeking an immigration benefit. And remember, abuse is not only physical, it can be psychological by the words they're saying, such as, I'm going to get you deported, or you will never get any documents, or, like psychological. Or also it can be financial, where they're taking all of your money or opening cars in your name and abusing you financially. All right. They're not only physical abuse, right? Thank you for tuning in, and I hope you got information that you can use going forward. I look forward to see you on our next program. Thank you.